Be seated. We'll have the dignitaries entering the hall very soon. And please switch off your mobile phones for the entire duration of the program. Thank you. The welcome address.
Thank you, Sudesh, and good morning. On behalf of the students, faculty, and staff of the National Law School of India University, Bangalore, I welcome all of the distinguished guests and who are here with us in person and joining us online to the inaugural Justice E.S. Venkataramiah Memorial Lecture. We are gathered here today due to the generous support and tireless efforts of Justice ESV's family, his daughter, Honorable Justice B.V. Nagratna, and his granddaughter, Advocate Nayanatara, personally, their efforts to advance the National Law School's interests in contributing to the public understanding of law and the Constitution. Honorable Dr. Justice Chandrachud, Chief Justice of India, and the Chancellor of the National Law School, has kindly agreed to deliver this inaugural lecture on the centennial year of Justice ESV's birth. We look forward to hearing you, sir, and your views on the theme of constitutional imperatives, a topic that was close to Justice ESV's professional and personal convictions. Justice ESV has a special connection to Bangalore, Karnataka, and the National Law School of India, and we are proud to be a host of this lecture. As a part of this welcome address, I will go over a few brief observations on an illustrious career. After an exceptional academic career with a first degree in History, Economics, and Political Science at Maharaja's College in Mysore, receiving several gold medals that were handed to him by the royal family of Mysore, the Vadiyars, and a second degree in law from the Raja Lakam Gowda Law College in Belgaum, he embarked on an illustrious legal career and as an advocate in the subordinate courts and as a law teacher at the Raja Lakam Gowda College in Belgaum. During his career as an advocate, he became the Advocate General of Karnataka and was elevated to the Supreme Court to then become the first Chief Justice of India from Karnataka. As a Chief Justice, he had an illustrious career, but I'm going to refer to just two opinions which have a bearing both on our reflection on his legacy as well as the lecture to follow. The first of these is his opinion in the Vasant Kumar case. In the Vasant Kumar case, Justice ESV and the bench had to deliberate and decide on the nature and basis for reservations with respect to the backward classes. There were two dominant views that emerged after post-independence India from the 1950s. The first was that economic criterion alone should form the basis of reservation identification in the backward classes category. Justice ESV, among other members of the bench, forged a new position in this field by developing a combination of caste-based criteria and class-based criteria to evolve a category called the backward classes. The recent decisions of the court would confirm that these questions remain alive in our times, are being worked through in the detail on the nature of empirical evidence and the nature of justification that is necessary in these cases. And Justice ESV's opinion is one that all of us read, continuously read, in the constitutional law classes that we teach and engage with our students. The second opinion that I want to focus on was a long concurring opinion in the S.P. Gupta case. The lawyers and law students in this audience understand very well that the S.P. Gupta case reshaped and redefined the position with respect to the appointment of judges in the early 1980s. Justice ESV was a concurring judge in the majority opinion, but wrote an opinion that was as much as 244 pages long. But it's not the length of the opinion that I would emphasize this morning. It is the nuance with which he approached the question of balance in the constitutional relations between important political actors, namely the executive and the judges, and partially the judges inter se. that position, counseling both caution and a degree of mutual respect between constitutional institutions, is one that we are yet working out in our times today. As members of this audience well know, we had one constitutional amendment. Uh, we've had one constitutional amendment on this question and several important judgments. And this question still remains a partially open question today. These opinions give us today a moment to reflect upon the legacy of Justice ESV as a judge, which some of us at the National Law School had the opportunity to, to directly experience, as he then, post-retirement, was appointed as the M.K. Nambiar Chair Professor in Constitutional Law. Professor Nigam and I had the privilege of being in those classrooms, as we had the privilege of being in Justice Rajendra Babu's classrooms when he took on that role. And I want to mention this in particular because universities benefit significantly from having personalities and figures like Justice ESV, who have occupied the highest offices in the country, coming back to engage undergraduates and graduates at our universities. We have benefited from that experience, and I take it that Justice Nagaratna's initiative to commemorate his legacy through this memorial lecture is another initiative in this direction, to build these relationships and to allow for the university system to grow through these engagements. So at this point, I will say no more. I know that we have a very impressive audience gathered here today, and we know we're here to listen to the Honorable Chief Justice. So I will say no more and hand over to Sudhish in the first instance. Sudhish, and let us go on to the main part of why we are gathered here today. May I welcome you once again, and thank you for joining us this morning.
Thank you, Professor Krishnaswamy. I now invite Justice B.V. Nagaratna, Honorable Judge of the Supreme Court of India and daughter of Justice E.S. Venkataramiah, to introduce today's speaker, Honorable the Chief Justice of India. Please, ma'am.
Namaskar and a very good morning to everybody. Honorable the Chief Justice of India, Dr. Dhananjaya Yashwant Chandrachud, fondly called as Dhan by his parents, Ms. Kalpana Das in absentia, my distinguished colleagues of the Supreme Court of India, Honorable Governor of Andhra Pradesh, Justice Abdul Nazir, Honorable Shri Justice Prasanna B. Varle, Chief Justice, High Court of Karnataka, and Honorable Chief Justices of Calcutta High Court and Himachal Pradesh High Court, Honorable Judges of the High Court of Karnataka and other High Courts, Honorable Chief Justices of various High Courts who are in absentia, former Chief Justices and Judges of the Supreme Court and High Court of Karnataka, Chairmen and members of the Bar Council of India as well as Karnataka, President and Office Bearers of Advocates Association, Bengaluru, Dharwad, Kalburgi, Supreme Court Bar Association, and as well as the Office Bearers of Supreme Court Advocates on Record Association, learned Principal District Judges and Judicial Officers from Karnataka and former Judicial Officers, learned Senior Advocates from Karnataka, Delhi, and elsewhere, members of all councils of National Law School, Vice Chancellor, Registrar, and faculty, past and present of NLS, Vice Chancellor of Bangalore City University, learned deans and faculty from various law colleges, distinguished invitees and guests, relatives, friends, and associates of Justice E.S. Venkataramiah, dear students, members of the press and electronic media, ladies and gentlemen. At the outset, I apologize for the lack of space but I'm overwhelmed with all your presence. I must express my gratitude to Honorable Chief Justice of India, Dr. D.Y. Chandrachud, who is also the Chancellor of the National Law School of India University, for so readily and very graciously accepting our invitation to deliver the inaugural Justice E.S. Venkataramiah Centennial Memorial Lecture here at Bengaluru. I thank each one of you present here today and online for having taken time off on a mid-December morning to reminisce and pay tribute to Justice Venkatamaya, whose 100th birthday is tomorrow. I thank the National Law School of India University for having accepted an endowment and a lecture series in the name of my revered father. NLS is close to me in three different roles: as a daughter of a teacher who taught there, a proud parent of an alumnus, and now as a part of the Executive Council. I have seen NLS from the days when the classes were being held in the Central College campus. In fact, Justice Santosh Hegde, then Advocate General for the state of Karnataka, my father, who was here in summer vacation, and myself as a young advocate, sat in the first class of the NLS in first week of July 1988. It is a matter of pride not just for Karnataka, but for the whole of India that NLS has produced fine legal minds who have excelled nationally and internationally. I have the pleasant duty of introducing the distinguished speaker, Dr. D.Y. Chandrachud, Honorable the Chief Justice of India. Dr. Chandrachud has created history as being the first Chief Justice of India, emulating his revered father, Justice Yashwant Vishnu Chandrachud, who had also created history for having the longest tenure as the Chief Justice of India. We are all well aware of the unique appeal that his lordship enjoys in the legal corridors and beyond. It is as much for his unfailing politeness and unmatchable sagacity as for his ability to empathize with human suffering, give law a human face, and his unflinching commitment to safeguarding the basic tenets of our Constitution. Interestingly, Justice Chandrachud almost did not turn to law and would have instead made a career in economics. Having studied and expectedly performed exceedingly well in the economics honors course at the St. Stephen's College in Delhi, I still remember his mother especially telling all of us how he stood first in the class. He was, a, he was to pursue a master's from the Delhi School of Economics. Writing about his Delhi University days in an essay titled A Tryst with Economics and Law, Justice Chandrachud has shared that having enrolled in the Masters in Economic course, since classes were due to start in a few weeks, he began attending lectures at the Campus Law Center, Delhi University. The intertwined questions of policy and constitutional morality with the quest for liberty and freedom that arose during those lectures led him to make the career-altering choice of pursuing LLB degree. I must say that our nation has been a beneficiary of that choice. I would not be wrong in saying that the field of economics and commerce has not suffered a loss either, for his lordship has made phenomenal contribution to commercial law jurisprudence through his judgments on insolvency law, debt recovery, corporate law, and financial regulation. Justice Chandrachud went on to pursue a master's in law, having been granted the prestigious INLAC scholarship, and also read for a doctorate in judicial sciences at Harvard University, Massachusetts. However, foreign education did not take away the pulse of Indian society from his lordship's heart. On completing his studies, he enrolled as an advocate with the Bar Council of Maharashtra and began his career as an advocate, practicing in Bombay High Court and the Supreme Court. He was amongst the youngest to be designated senior advocate at the age of 39 in the year 1998. He also served as additional Solicitor General of India from 1998 to 2000 until he was appointed as a judge of the Bombay High Court. In 2013, he was appointed Chief Justice of the Allahabad High Court and was elevated to the Supreme Court in 2016 and assumed office of the Chief Justice of India in November 2022. Sorry. In Chief Justice D.Y. Chandrachud, we see not only great scholastic achievements, but that are also coupled with humility and empathy. The Chief Justice is a fine blend of softness and firmness personified. I was fortunate in my early days in the Supreme Court of India to be a part of his bench. The manner in which he handled the court those days and still now, while remaining most polite and calm, the ease with which he navigates through complex legal questions, the sincerity with which he upholds the fair name of justice, and the distinction with which he presides have been truly inspiring for me. Justice Chandrachud's tenure as a judge may be categorized by one monumental case after another on issues covering every ray of the spectrum. His judgments have played a critical role in embedding the ideals of privacy, decisional autonomy, and dignity through his judgments in Justice K.S. Puttaswamy and Navtej Johar. His judgment in Mohit Minerals has been hailed for strengthening the ideal of cooperative federalism. His lordship has materially championed the cause of substantive equality for women in public employment and within the private sphere through his judgments in Babita Punya, Colonel Nitisha, and Joseph Shine. The opinions in Madhyamam Broadcasting and Indebly Creative have deepened the constitutional protection for free speech and expression, while his judgment in Patal Jamal Wali inaugurates the juristic development of the concept of intersectionality in Indian jurisprudence. Vikas Kumar and Avni Prakash give effect to the international and domestic obligations towards empowerment of the persons with disability. These outstanding accomplishments on the judicial side are matched by his farsightedness in taking the Indian judiciary to the 21st century and beyond, and will be presiding over the celebration of 75th years of the Indian Supreme Court. Justice Chandrachud has led the work of the E-Committee of the Supreme Court, which include far-reaching improvements in the digital infrastructure in courts across the country. During his tenure, the ideal of access to justice has been amplified in all its dimensions. The Supreme Court has conducted an audit and produced a comprehensive report on the accessibility of its premises for the elderly, pregnant women, and persons with disability, which is just one of the several reforms. The report was recently submitted by a committee headed by Justice Ravindra Bhatt. The employment of new artificial intelligence technology to break barriers of language in access to the judgments of the Supreme Court through the ESCR portal would go a long way in increasing the litigants' trust. The publication of the handbook on gender stereotypes would further deepen public trust by correcting pernicious anti-woman prejudice that continues to haunt the legal profession and women's quest for justice through the judicial process. Throughout his career as a judge, his lordship has created a progressive, liberal, inclusive ethos in the legal profession. He continues to leave his indelible stamp on the vital judicial organ and through that on our nation as a whole. Sorry. It is no coincidence that Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, has agreed to deliver this inaugural Centennial lecture. I would be remiss in not paying my tribute to Chief Justice Y.V. Chandrachud, for he opened the doors of the Supreme Court to judges of the Karnataka High Court by recommending the appointment of my father in January 1979. Earlier, Justice K.S. Hegde of the Mysore High Court was elevated from the Delhi High Court, and there was no other judge from the Karnataka High Court in the Supreme Court. Coincidentally, it was on 18/12/1978, here in Bangalore, that Justice Y.V. Chandrachud expressed his intention to recommend Justice Venkataramiah as a judge of the Supreme Court of India. I may recollect that Justice Chandrachud, the present Chief Justice, came with his parents in December 1978, and I may also share with this audience that Chief Justice D.M. Chandrasekhar, I think, was not interested to go to the Supreme Court, and therefore the choice fell on my father. On the occasion of the Golden Jubilee of the Karnataka High Court in the year 2006, Chief Justice Y.V. Chandrachud expressed his thoughts and sentiments on my father in a fine literary piece titled Smiling Yet Serene Venkataramiah. And I quote a few lines from that piece. I regard it as a precious gift of destiny that a warm-hearted gentleman like ESV was one of my closest and finest friends. He was not only a good judge, but he was a good teacher of law. My analysis of ESV as a judge begins with a few preliminary observations. The Constitution spoke directly to him as a person, a judge, and an Indian citizen. He conceived of the Constitution as an embodiment of values that he believed in and as a basis of granting him, as a judge, power to protect those values. He repeatedly emphasized that he had a duty under the Constitution to see that his understanding of the imperatives was implemented, and he saw the Constitution's imperatives as basically ethical in nature. Those imperatives that he read into the Constitution were so clear to him, and his duty to implement them so transparent, that matters of doctrinal interpretation and of institutional power became nearly irrelevant to him. That is why his erudition was unspoken of and not perceptible to the passer-by. The ethical imperatives that guided ESV as a judge reflected his personal morality in that he held a set of values that he believed represented moral truths about decent, civilized life. It was inconceivable to him that these values would not be embodied in constitutional principles, since he believed that they formed the essence of our democracy. In the now emerging public world of corruptible and self serving persons, he set a standard of incorruptibility and humanity. Unquote. I will take only a few minutes to say how true those words are. Even before the coming into force of the Constitution on 26 January 1950, Justice Venkataramiah, as a young lawyer, had set up the Legal Aid Society in 1948. Access to justice, much before it gained institutional currency, was an article of faith for him. This principle manifested in his making a mark as a trial lawyer, known for his capacity to marshal facts, attention to detail, and clever cross examination skills, coupled with his sound knowledge of legal doctrine. His arguments in the famous Drayton murder case in the late 1950s in the High Court, which was a legal aid brief, saved an innocent person from the gallows and won accolades for Venkataramiah. His motto as an advocate was intellectual honesty, personal morality, and eagerness to secure relief to the litigants as early as possible. In one of his addresses at the Bar Council of India function in Jaipur, Justice Venkataramiah paid tribute to the Bangalore Bar for supporting his professional growth, although he was not from Bangalore and a first generation lawyer. He credited his colleagues at the bar for imparting strength to his faltering steps. Perhaps in recognition of this support, he was the first to recognize the needs of a young lawyer and made sure to pay a stipend to his chamber colleagues every month, even at the risk of personal financial hardship, which was only transitory. I'm informed that it was only rupees 100 those days, but quite a lot nowadays, I suppose. And I wish that tradition continues with the seniors vis-a-vis their juniors. There are many judgments which are a window into his constitutional philosophy. I would like to highlight a few of them. In A.K. Subbaiah versus Chairman Karnataka Legislative Council, which was a petition instituted in public interest by two members of the state legislature, alleging that certain derogatory remarks were made on the floor of the House concerning the conduct of judges, Justice Venkataramiah, while dismissing the petition, wrote, and I quote, "Was it not Voltaire who said like this, 'I do not agree with you, but I will fight for upholding your right to disagree with me till the end of my life'? In the same spirit, this court, which has a special obligation to uphold the Constitution and the laws, upholds Article 194(2) of the Constitution and the immunity guaranteed to the members of the legislature thereunder, leaving it to them to uphold Article 211 of the Constitution in their deliberations. I am of the view that no action is called for in this case," unquote. In this case, my father remembered Chief Justice Subodharanjan Dasgupta, whom he considered to be an ideal, and he said, and he quoted what Justice Dasgupta said, that a judiciary is one which consists of judges who are independent of themselves. The said words found resonance in the famous first judge's case, S.P. Gupta versus Union of India, in which he was the junior-most member of the seven-judge bench presided over by Justice P.N. Bhagwati. His judgment comprised of 339 pages. Except for the extracts from correspondence and provisions, the rest of the judgment was personally handwritten by him. He ensured that his judgment was the first to be circulated to his senior brethren, so that his views on the subject of appointment and transfer of judges were made known to them, lest there should be any inroads into his thinking and convictions. I observe that it was his conviction, courage, and independence which in a way strengthened the Supreme Court as an institution as well as the judiciary. I have personally witnessed the unique journey of drafting that judgment, particularly in November 1981, and except for 3 days which interspersed during that writing, he had to take leave because my maternal grandfather died on 25th November 1981. He continued with the writing, and I may mention also, except for those 3 days, in his tenure of 10 years and 9 months, he didn't take any leave on any other day. Deeply distressed, and his judgment has been, and he spoke about his ideas and thoughts which he reflected in his opinion. Deeply distressed by the extent of injustice and prejudice caused to the petitioner on account of a special procedure, Justice Venkataramiah stated in the court, quote, if Article 14 was applicable to Anwar Ali Sarkar, why not to Abdul Rahman Antule, unquote, which culminated in a reference to a seven-judge bench to examine the extent to which special procedure prejudiced the accused or the petitioner therein. Sitting along with Justice Savisachi Mukherjee, the reference order consisting of 10 questions was heard by a seven-judge constitution bench headed by Justice Mukherjee, and by a 5-2 majority, the reference was answered in favor of A.R. Antule. Thank God, the doctrine of stare decisis does not apply to the Supreme Court of India, which enables a judge to question the correctness or otherwise of a larger bench decision. I remember my father in April 1988, when I had gone back for summer vacation from Bangalore to Delhi, sharing with me his fond hope to be vindicated, not as a personal vindication, but as one that would uphold the right to equality in its truest sense. He was indeed vindicated. I do not wish to prolong by speaking more about his judgments, except touch upon the fact that he was a votary for freedom of speech and expression, which are expressed in Indian Express newspapers, Bombay Private Limited. Being fond of the game of cricket, he was extremely unhappy and distressed that the BCCI had suspended 6 cricketers. And Mr. K.N. Bhatt, who is present here, he was the one who argued that matter. And he said in the open court, and I quote, get on with the game on the field and not in the court. This statement made the BCCI lift the suspension of the 6 cricketers. Many of the judicial officers present here would know that in Ishwar Chand Jain, Justice Venkataramiah ruled that the High Court must take steps to protect its honest judicial officers by ignoring ill-conceived or motivated complaints made by unscrupulous lawyers and litigants. My father was keenly interested in Sanskrit scholarship. In fact, those days the court opened at 11 a.m. and between 8:30 a.m. and 9:30 a.m. there was a Sanskrit teacher who came home to teach him Sanskrit. He not only seriously studied several famed Sanskrit works, English and Kannada literature, some of the works also find mention in his judgments, particularly in the last paragraph of the first judge's case judgment. He had the unique distinction of being a judge of the Supreme Court longer than a judge of the High Court. Though he was a judge of the Supreme Court of India, the soil of Mandya always beckoned him. He never forgot his roots. He remembered his village, his district, his state, as much as he did his people. In fact, during the last days when he couldn't speak, he wrote on pieces of paper, I am praying for Bharat. In short, Justice Venkataramiah was a scholar and a gentleman. He was a realized soul, for he believed work is worship and sharing knowledge, and by sharing knowledge, one does not lose anything. My mother's world revolved around my father. She stood like a rock behind him, and she was known for her pragmatism and straightforwardness. With this, I thank each one of you for your kind attention, and I would now like to invite Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, to speak on the topic Constitutional Imperatives of the State, Navigating Discrimination in Public and Private Spaces. Thank you for your kind attention. Namaskar.
after this very moving introduction, I wish I had the joy and honor of saying I agree and then resume my seat. Distinguished former judges of the Supreme Court of India, my very dear sister, Justice B.B. Nagaratna, members of the family of Justice Venkataramiah, Chief Justice Prasanna Varale, and judges of the Karnataka High Court, both emeritus and sitting, Dr. Sudhir Krishnaswamy, Vice Chancellor, National Law School of India University, Dr. N.S. Nigam, Registrar of NLSIU, members of the faculty, senior advocates, distinguished guests, and dear students. It is a matter of great pride and honor to deliver the Centennial Memorial Lecture commemorating the life and legacy of former Chief Justice of India, Justice E.S. Venkataramiah, ESV. I'm overwhelmed by the weight of the occasion, the presence of this galaxy of intellectuals, and above all, the erudite judge in whose memory the series is instituted. But I take this occasion also to pay my own personal tribute to the abiding friendship of Nagaratna's parents with my own. They maintained that friendship both on the bench and in the years that followed after they had ceased to be judges of the Supreme Court. Justice E.S. Venkataramiah was the 19th Chief Justice of India. He started his journey as a lawyer in Bangalore. He went on to be elevated to the bench of the Karnataka High Court and eventually found his way to the Supreme Court, in whose service he spent over a decade. Though his legal journey is nothing short of inspirational, he would often quip that he went from SCC, that is the small cause court, to SC, that is the Supreme Court. But anyone who knew him and his work would attest that he was a teacher and an academic before being a lawyer or a judge. His practice of the law was always accompanied by his academic endeavors. In the Supreme Court of the 1980s, among the distinguished judges who comprised the bench, there was then, as there is now as well, a great sense of camaraderie among the judges. Judges are popularly nicknamed by colleagues on the bench. There were two who had this nickname in those days. I will disclose the identity of one, but not of the other. One of those judges was nicknamed Lord Wilberforce. The other was nicknamed Swamiji by my father. And as you've probably guessed, Swamiji was nicknamed as Swamiji because of his great erudition in Sanskrit and spirituality, and that was Justice Venkataramiah. I'll leave you guessing about who Lord Wilberforce was. When I think of his academic career, I'm reminded of bookends, which is how his teaching punctuated ESV's legal practice. He started teaching law in 1945, at the same time as he enrolled at the bar, and was actively engaged in teaching law at various law colleges throughout his career. After hanging his robes as a judge, he was appointed the M.K. Nambiar Chair for Constitutional Law here at NLSIU. Teaching the law in many ways was his first and last love. Naturally, then, the many landmark judgments that he authored are impressed upon by his profound body of academic work, touching upon a wide range of issues such as human rights, freedom of the press, federalism, and citizenship. In his judicial writings, we see an empath, an environmentalist, and a champion of free speech. He was a fierce defender of judicial independence in S.P. Gupta versus Union of India in 1981. We saw in him a champion of freedom of the press in Indian Express newspapers versus Union of India in 1985. where he balanced the freedom of press with the taxing powers of the state, writing that as long as the court sits, newspaper men need not have the fear of their freedom being curtailed by unconstitutional means. In MC Mehta versus Union of India in 1988, he separated the financial capacity of the tanneries discharging effluents into the Ganga from their obligations towards the environment. He held it was not merely a directive principle of state policy under Article 48A of the Constitution to protect and improve the environment, but a fundamental duty of the central government to, quote, as I say, direct all educational institutions to teach at least 1 hour a week lessons relating to the protection and improvement of the natural environment, including the forests, the lakes, the rivers, and wildlife in the first 10 classes. As many of you would know, he was writing this judgment when the environment law in the country was still in its early stages. He was thinking way ahead of his times for the environment and also for the future generation of the country. Justice Benjamin Cardozo, a former US Supreme Court judge and scholar, wrote that it is a judge's inevitable duty to decide based on their experience, study, and reflection. In Justice Venkataramiah, we find an exemplar judge who just did that. A perfect blend of pedagogical and judicial acumen, Justice Venkataramiah's two worlds often collided. As his juniors in the profession and also as citizens of this country, we have had the distinct benefit of insight into his wonderful mind and his musings through his judgments and his published works. Therefore, before I begin, I must thank my very fond sister, Nagu, for having given me this great honor to be here. The academic in ESV would approve of a lecture in his memory. I thank Justice Nagaratna for organizing this lecture and having me. I have chosen for myself the theme of constitutional imperative of the state, navigating discrimination in public and private spaces. In choosing this subject, I draw inspiration from the words of Justice ESV's colleague and brother in SP Gupta versus Union of India, Justice P.N. Bhagwati. Underpinning the importance of an independent judiciary, he cast a wide role for the courts of a society that is, as he said, pulsating with urges of gender justice, worker justice, minorities justice, Dalit justice, and equal justice between chronic unequals. It makes one think whether, as such a pulsating society, we have succeeded in creating public and private spaces that are conducive to people across dividing lines. Whether the laws and policies we adopt further the objects of the Constitution in both these spaces alike. In creating our public offices, our lawmakers and constitution makers assumed that these offices would come to be occupied by righteous persons who would exercise their discretion wisely. That's why Dr. B.R. Ambedkar said on the last of those speeches before the adoption of the Constitution, that the Constitution will be as good as the people who operate her. The law presumes, for instance, that civil and criminal courts, which are vested with wide-ranging inherent powers, will exercise those powers to do complete justice. But what is justice? Is my version and understanding of justice the same as one of yours? Is there only one form of justice? If it is a rigid singular concept, then why do we have overturning judgments? We just overturned one just a few days ago in a combination of 7, less than 6 months after the earlier one was delivered. A person's sense of justice emerges from their conscience. A lot of factors contribute towards molding a person's sense of justice, such as the interactions of people, through reading, or in many cases, just by observing. For example, my sense of justice on issues of gender evolved with my interactions with my own spouse, Kalpana, with my interactions with Justice Sujata Manohar and Justice Ranjana Desai, with whom I was sharing the bench at the Bombay High Court with Justice Ranjana Desai. Our sense of justice evolves when we are ready and willing to open our minds beyond the assumptions that the society has taught us to hold. It is only when we have an open mind are we likely to feel the need to deviate from some of these base assumptions to curate our own sense of justice. We often see this need to deviate take the form of legal amendments and overruling of previous decisions that were perfectly valid until a point of time. The law, in that sense, responds to social change as the fundamental assumptions underlying it alter over time. One such assumption is the difference between public spaces and private spaces. As a society, we ascribe certain roles to certain persons. These ascribed roles may not always be based on objective abilities or their lack, but rather on certain subjective norms. Artificial markers of ability, aside from one's skills, such as gender, class, caste, and disability, often come to define the roles we give to ourselves. For instance, purely on grounds of gender, women are often perceived as natural caregivers who must tend to the domestic needs of the family, while the men must undertake remunerative activities and form the financial axis of the household. It's so untrue. In my own personal life, I was the sole caregiver of a spouse who was battling cancer for almost a decade. Much as we have designated roles to genders, since these roles are location sensitive, we have also demarcated neatly the public space and the private space where each of these must be performed. Our laws, as we shall see in due course, have crystallized this narrative of what is public and what is private. Our laws and policies choose to treat people based on the physical location of their actions. To substantiate this point, the Indian Penal Code provides that when two or more persons, by way of a brawl in a public place, disturb the public peace, they are said to commit an offense of affray. We must note that a brawl between two people will be punishable only if its location is a public place and not otherwise. The thrust of the law, therefore, is not only the inherent merit or demerit of brawls, but on whether and where they take place. While there may be some merit to this distinction in certain situations, a holistic, constitutionally governed society must be willing to look beyond this binary of public and private. This dichotomy between what is private and what is public has formed the basis of the feminist and economic critiques of our laws and policies for several years. For freedom of expression to truly exist, it must exist in both these spaces. It cannot exist in one and not in the other. Both these spaces do not exist in neat individual spheres like that of a Venn diagram. They often overlap. The same hierarchy that pervades the private way seeps into the public and vice versa, making both spaces slightly less equitable. There is therefore a need to look beyond this binary of what is public and what is private and search for the grievances that underlie both these spheres. For instance, the household, which is understood as a private space, is a site of economic activity by a homemaker who is not remunerated for it. Similarly, in public spaces, women are consigned to distinctively feminine, service-oriented, and often sexualized occupations. Thus, both sides involve rights and their infringement. However, if the law chooses that it will interfere only in the latter, namely the public spaces, perhaps because of its visibility, the law would be unjust. The framers of our Constitution did not envisage such a geographical application of the law. There is increased percolation between those two locations whose oppressive biases and prejudices have transcended the boundary between the public and the private. Therefore, fixating on the public-private rather than identifying both of their common problems furthers stereotypes about gender, ableism, and many such identities. These stereotypes create a self perpetuating loop of who belongs where and entrench the unjust outcomes of both the public and the private. Having said that, I believe that this public private paradigm and its underlying assumptions could serve as a framework for examining our institutions to some extent. This is, in a way, a furtherance of the critique of this divide. As the division between the two spaces evaporates, we must examine our preparedness to secure the rights of our people in this new realm, which is neither wholly public nor wholly private. With technology virtually ending the spatial constraints, we must examine how our laws and institutions can overcome the limitations of both public and private spaces. Our laws and procedures must expand beyond this binary and identify the oppression and the oppressed wherever they may be. Even beyond that, we must ask ourselves what happens when the conventional public and private spaces are inhabited by those not stereotypically associated with them, in situations that are uncharacteristic of that geography. When a private home is a site of employment for a house help, does the law protect their economic and personal rights as much as it does the rights of a corporate office employee? The purpose of the law would have to be extended to safeguard the interests of the conventional and the unconventional participants of both these situations. Let me, in the first part of my presentation this morning, deal with gender discrimination from the perspective of this public and private divide. Between an individual and a state lies a whole litany of institutions that mediate and define the individual's existence with respect to the state and in of themselves. Institutions of the family, marriage, religious institutions, educational institutions, healthcare organizations, and non-governmental organizations form a part of the relationship that we have with our governments, with our courts, and with each other. These institutions also influence our access to resources and opportunities alongside social markers of identity such as gender. For instance, a 2018 report on women in prisons by the Ministry of Women and Child Development found that abandonment of women inmates by the members of their families is a frequent phenomenon. These women are left on their own to lead a solitary legal battle. The reasons could be social stigma and financial constraints to pursue legal remedies, or the general dispensability of the individual to the continuance of the family itself. The inherent merits of our laws and our legal aid aside, the institution of family is critical to the inmate's ability to access the law for herself. Without such support, she may eventually be able to find her way to the courts on the strength of legal aid, and the void created by one institution of the family may eventually be filled in the form of legal assistance. But the woman stands on shakier and uncertain grounds until that happens. Such is the influence of these institutions that they not only mediate a person's ability to access the law, but also sometimes prevail over the legal rights of the individuals themselves. Our courts have in the past, in fact, privileged these institutions over the individual. Our courts have held that the need to preserve the institutions is greater than the need to protect the individual's rights. For instance, it was long held in the context of marriage and marriage laws and the scope of court's intervention that introducing the tenets of constitutional law in the privacy of the home or a marriage would weaken the institution of marriage itself. The sensitive sphere was considered to be an intimate sanctuary, immune from the applications of the cold principles of constitutional law. In all fairness, this tendency to insulate private lives of individuals is well founded, even if we may disagree with effects such as the ones I just mentioned. After all, privacy is but an extension of personhood and dignity. Beyond privacy, as a right, is a guarantee against the excessive intrusion of the individual's life by both state and non-state actors against excesses of the public and private authorities. It affords an effective barrier against surveillance, against restrictions on expression. What is then the harm, I ask myself? What is then the harm in stopping law at the threshold of the household? The answer lies in the fact that the household, as much as it provides a private sanctuary to its inhabitants, is not simply by that reason an equitable space. Despite the general sense of security households offer, there is a fair chance that these spaces may become unequal and unfair to some. It is not uncommon to hear that when faced with a financial choice between the education of a male child and a female child, the family will choose in favor of the former, the male child. There are subtler versions of this inequality. The pressures a woman faces when stepping out of the household for her education, profession, or recreation do not exist for her male counterparts. If the hierarchies persist in the private space and the law looks the other way in the name of the sanctity of the household or the sanctity of marriage, we would be failing in the promise of equal protection of law and qualifying it with a caveat based on the location of the wrongdoing. This would be a diluted understanding of what privacy entails. It is not a cloak for infringement of the rights away from the watchful eyes of the law. It is a guarantee against excesses and not against the very reach of the law and due process. Perhaps my own sagacious mother had a joke on this, which I will just share with you. There was a Marathi play at that time which was titled Ai Retire Hote. The mother retires. And she would constantly remind us of what would happen to us if this mother in the family retired, if I retired. Hierarchies, prejudices, and stigmas travel beyond the public-private binaries. But fortunately for us, just like the problem, the solution is equally fluid. And it is in the fluidity of legal solutions and social solutions that judges exercise their craft. The gains of improving our private lives will reflect in our public life as well. As we began to recognize that these private structures are not constitutional vacuums, and injustices in private spaces are also indeed what they are, unjust, we were able to better assess their role in society. This did not happen overnight. The dissolution of the barrier between the public and private lives of women is what led to this change. Very recently, in Deepika Singh versus Central Administrative Tribunal, the denial of maternity leave based on a woman's previous marriage circumstances was challenged. This woman was denied maternity leave on the ground that her husband from a prior marriage, which had ended in the death of the first wife, had two biological children, and she was, though the biological mother for the first time, as between her and the husband, she had three children, and therefore she was denied maternity leave. Interpreting Section 3C of the Maternity Benefit Act of 1961 and correlating the definition of delivery with it, a bench of the Supreme Court of which I was a part held that the act aimed at securing women's right to pregnancy, maternity leave, and affording reasonable flexibility to live both as a mother and as a worker. It then took up the challenge to Rule 43 of the Central Civil Services Leave Rules of 1972. The judgment clarified that the distinction between childcare and maternity leave, ensuring civil servants have access to both, by rejecting stereotypical ideas of what a family is, the court embraced inclusivity for diverse family structures. This decision reflected the evolving societal norms and the need to reimagine family concepts beyond conventional nuclear models. In Kriti versus Oriental Insurance, the Supreme Court held that in deciding the compensation for the loss of life in a motor vehicle accident, we have to account for the value of a homemaker's labor within the household. The fact that such labor is not economically measured by our society could not be perpetuated and furthered by the court's refusal to interfere. The basis of the public-private divide And the perception that courts and laws apply differently to both spaces is inaccurate. The aged notion that what men do is public, what women do is private, has no application in societies governed by constitutions. We have come to realize that these spaces cannot be appropriated by a particular class of people at the cost of the rest. The public places and public spaces are for everyone who wants to access them and cannot be made prohibitively difficult to reach for some. Public spaces are more than mere containers of social action. Public space is defined not by its use for the public alone. They are spaces that structure the very nature of our discourse. It is, of course, unfortunate if our public spaces in their actual form do not represent the diversity of our country. But what is more concerning for us as sentient beings is the loss of discourse in our society today. How do we incorporate changes that make our institutions more inclusive without hearing the voices of the people whose representation we are talking about? Without such a discourse, our policies would only have the benefit of the observed experiences of a select few rather than the benefit of the lived experiences of our people. We cannot, despite our best intentions, walk in their shoes. We can merely pave the way for their effective participation in decision making. We need spaces of representation for representation to truly happen. This principle applies to public spaces just as much as it does to the private sphere. Public spaces and public lives, as Hannah Arendt puts it, represent certain values. It is in these realms that men can be truly free, she said. Public spaces to Arendt represent spaces that were premised on a certain equality of peers, where individuals purposely came together in their efforts towards improving the lives of people and consolidated the efforts against tyranny. The public space was thus the avenue of realization of personal and social goals. A democratic society, its laws, and its institutions are supposed to enable exactly this kind of congregation of minds for better social outcomes. Our Constitution is a testament to what deliberations can offer. For that, in turn, our institutions must facilitate this plurality. The challenges faced by women and other disadvantaged groups transcend mere ideas of visibility, weaving a complex tapestry within the public sphere. The glass ceiling, an elusive yet formidable barrier, encapsulates these challenges, impeding the progression of capable women in both professional and personal spheres. It obstructs the upward mobility of talented women, demanding a nuanced understanding to navigate a path towards dismantling these barriers. India's first female physician, Rukmabai, was a woman who bravely challenged societal norms and patriarchal constraints in the late 19th century, such as the practice of child marriages. She became a symbol of resistance against regressive practices, setting a precedent for women to defy societal expectations and pursue their aspirations. The fact that she was herself married at the age of 19 did not stop her from championing the cause of other women who faced a similar destiny. Her efforts eventually led to the enactment of the Age of Consent Act of 1891. This is not the story of Indian women alone. The movie Hidden Figures provides a resonating example. I just watched the movie on a flight recently back to India from the US. And this movie provides an example how this is reflected on a global scale and affects all individuals. This cinematic piece provides a compelling portrayal of Katherine Johnson, an African American mathematician, and her colleagues who played pivotal roles in NASA's space missions. In a poignant scene, Katherine confronts racial and gender biases as she asserts her expertise to calculate trajectories of space flight. This moment lays bare the systemic hurdles women of color face in professional arenas, showcasing the resilience required to break through the glass ceiling. The echoes of Catherine's struggles resonate with the pervasive nature of gender discrimination faced by women in various spheres of our life. The challenges depicted are not confined to the realms of fiction or movies. They mirror the battles faced by women in the public sphere. Delving into legal precedents further emphasizes the persistent nature of gender discrimination, unraveling in narrative that extends beyond the boundaries of the film set. For instance, in Anuj Garg versus Union of India, the constitutional validity of the provision of the Punjab Excise Act restricting the employment of women in establishments serving intoxicating substances was challenged. The court observed that the provision, being a pre-constitutional law, needed review given changed societal conditions. It struck down the provision asserting that it perpetuated sexual differences and restricted a citizen's right to be considered for employment. Likewise, the decision in Charu Khurana versus Union of India, which struck down the discriminatory bylaws of the Cine Costume Makeup Artists and Hairdressers Association of Mumbai. These legal vignettes not only spotlight the intricacies of gender discrimination, but also underscore the adaptability of legal frameworks in addressing contemporary challenges. Courtroom battles in cases like Deepika Singh reveal the dynamic nature of the law and its capability of responding to evolving societal norms. These legal victories serve as beacons, illuminating the path towards a just and more equitable society. The transformative impact of legal intervention against gender-based discrimination is evident, heralding a new era of consciousness and accountability in our society. However, as we celebrate these victories, the quest for true equity still persists. Despite legal victories and societal movements, subtle forms of bias and discrimination persist. For instance, workplace discrimination, microaggressions, and unequal opportunities continue to undermine the principle of equality. Another persistent challenge lurks behind the gender pay gap. This issue is particularly pronounced for Indian women, especially those belonging to marginalized communities. Despite their significant contributions to various professional spheres, women continue to face disparities in remuneration compared to their male counterparts. Nobel laureate Claudia Goldin, in her research, has actively reflected that women are vastly underrepresented in the global labor market, and when they work, they earn less than men. The disconcerting reality of the gender pay gap in India illuminates a complex interplay of factors, including societal norms, cultural expectations, and systemic unconscious biases. The pay gap widens as it intersects with other forms of discrimination, amplifying challenges for women who navigate both gender and racial biases. This is a stark reminder that achieving true equity requires more than legal provisions. It demands ongoing advocacy and systemic changes to dismantle entrenched biases and ensure equal opportunities for all. Efforts to bridge the gender pay gap must address intersectional discrimination faced by Indian women. Advocacy should encompass not only gender sensitive policies, but also initiatives that recognize and rectify the unique challenges faced by women from diverse backgrounds. In the second part of my presentation this morning, let me dwell on disability rights. I would like to speak about the public-private divide in the realm of disability rights. Disability often becomes a barrier, denying individuals access to public opportunities due to societal biases, perceiving disability as a limitation. Even when given a chance, essential accommodations might be missing, like offering a job to a person with a disability, but lacking necessary workplace tools or infrastructure, hindering their success firsthand. Moreover, individuals with disabilities often encounter doubts about their capabilities after receiving opportunities as a result of ingrained ableism. I remember my former law clerk, a Rhodes Scholar, who is visually impaired, telling me that they face skepticism, especially in a job interview for tech-driven roles. This limits their growth due to biased assumptions about their disabilities. The judiciary in the state of Karnataka is among the highest number of employers, of persons with disabilities, particularly in their staff. As part of the E-Committee, training to equip these members who are differently abled with ICT tools has opened up a whole new universe for them. This can also be exemplified through the Oscar-winning film Rain Man in 1988. In the film, the main protagonist, Raymond, who has autism and Savant syndrome, faces skepticism rooted in ableism regarding his task abilities. This is akin to real-life scenarios where skills of individuals with disabilities are doubted despite meeting requirements, perpetuating exclusionary biases. The ratification of the Convention on the Rights of Persons with Disabilities in 2007 signaled a paradigm shift, aligning India with the social model of disability and human rights. This global commitment to inclusivity has had a profound impact on subsequent legal interpretations and intervention. The legislative journey is a narrative of progress from a charity-centric mindset to the acknowledgement of rights as inherent in every person. Post the ratification of the convention, Indian courts creatively embraced principles emphasizing non-discrimination, reasonable accommodation, and affirmative action while deciding issues which concern disability rights. In Jija Ghosh versus the Union of India in 2016, the Supreme Court strongly condemned discrimination against Jija Ghosh, who was deboarded by an airline due to her disability, awarding damages and highlighting the impact of social barriers on disabled lives. In Vikash Kumar versus Union Public Service Commission in 2021, our court observed that individuals with writer's cramp or dysgraphia, not recognized as a benchmark disability in the Rights of Persons with Disabilities Act, are entitled to a scribe in a civil services examination. This decision underscores the principle of reasonable accommodation under the RPWD Act, emphasizing the positive obligation of state and private entities to provide support for full participation. It marks a significant shift from a medical to a human rights model of disability, aligning with the convention. This has been showcased in recent judgments, such as Ravindra Kumar Dhariwal versus Union of India, which is of 2022. In this case, the Supreme Court revitalized Article 14 by invoking inclusive equality and reasonable accommodation. It addressed whether disciplining a Central Reserve Police Force assistant commandant who developed a mental disability during employment was discriminatory. The court emphasized the importance of dignity and equality under Section 3 of the RPWD Act, highlighting the state's positive obligation to fulfill the rights of persons with disability. Section 20 expands the obligation to provide reasonable accommodation, leading the court to conclude that the scope of this obligation has significantly broadened. Cases like Akanksha Singh versus the High Court of Delhi also highlight a commitment to accessibility, expanding the scope of disability under the Rights of Persons with Disabilities Act in 2016. Courts, in cases such as these, rejected categorizing bipolar disorder as a sign of incapacity, emphasizing the capabilities of individuals with mental health conditions. Courts have also recognized and enforced the principle of accessibility, directing the University Grants Commission to establish accessibility guidelines for higher educational institutions. The judiciary, while recognizing intersectionality of gender and disability, has recognized the vulnerability of disabled women, emphasizing the potential for indirect discrimination they may face. Recent cases serve as illustrations of the judiciary's evolving role, not only in recognizing individual rights, but in addressing intricate intersections of disability with gender and mental health, further enriching the discourse on equality. This underscores that disability is nuanced. It's an individualized concept shaped by factors like mental impairment and personal circumstances, rejecting a one-size-fits-all approach. The legal framework emphasizes the need to avoid stigmatization and discrimination against individuals with mental health issues or disability, recognizing the impact on their sense of disability. This imperative aligns with the concept of universal design, which embodies the essence of inclusivity by advocating for spaces that embrace and accommodate everyone irrespective of ability. An architectural access audit has recently been conducted by the Supreme Court's Committee on Accessibility of the Premises under the able guidance of my very distinguished colleague, Justice Ravindra Bhatt, who is fortunately present in the audience. Such audits play a crucial role in evaluating the accessibility of buildings and public spaces. These audits identify barriers and recommend modifications, ensuring that spaces go beyond legal compliance to demonstrate a commitment to human rights, social responsibility, and fostering inclusivity and diversity. The Supreme Court Committee on Accessibility's meticulous approach in its report, Auditing the Supreme Court's Facilities, provides invaluable insights into the existing challenges. From physical accessibility issues like the absence of wheelchair friendly amenities to functional challenges such as the lack of sign language interpreters, the report paints a comprehensive picture of the challenges to accessibility and inclusion. The identification of gaps in physical and functional accessibility is not merely an exercise in critique, but a strategic move towards an inclusive reform. The report's recommendations ranging from introducing accessible route maps, to overhauling restrooms for better accessibility showcases a commitment to tangible solutions. We are currently on the path to adopting the suggestions outlined in the report by Justice Bhatt, which seeks to comprehensively address concerns about accessibility and inclusivity within the legal system. This involves physical improvements such as accessible routes, designated parking, along with the establishment of dedicated sections, mediation protocols, and enhanced facilities like accessible restrooms and lactation rooms. Cases involving individuals with HIV are prioritized, and de-identification measures during legal proceedings have been implemented. Additionally, we use technology with tailored online resources for persons with disabilities, highlighting the importance of inclusive digital spaces. Therefore, universal design, as both a concept and a practical approach, becomes a tool to break the cycle highlighted in Anuj Garg. It is not just about addressing existing barriers, but ensuring that the design of our spaces inherently considers the diverse needs of all our individuals. The recognition of the role of technology aligns with the principles of universal design, extending the reach of inclusiveness beyond physical spaces to the virtual realm. The role of technology in shaping inclusive spaces extends beyond just convenience. It becomes a democratizing force, ensuring that access to information and legal processes is no longer a privilege but a right. The Supreme Court's E-Committee has in its initiatives underscored just this, emphasizing the need to make filings accessible to lawyers with visual impairment, ensuring proper placement of stamps and watermarks to promote accessibility through assistive technology, and making captchas on the Supreme Court and High Court websites accessible. Recently, the Supreme Court has begun providing sign language interpretation for lawyers with hearing impairments. This was demonstrated in a recent case where a hearing impaired advocate, Ms. Sara Suni, was allowed to argue virtually with the assistance of a sign language interpreter in our court. As we navigate through these legal landscapes and policy considerations, the concept of crip theory emerges as a revolutionary force. Crip theory, born within the realm of disability studies, stands as a powerful tool to explore the experiences of individuals with disability, acknowledging the historical exclusion and social barriers which they face. Developed at the intersection of gender and sexuality, crip theory forms an integral part of critical disability studies. Crip time A profound aspect of this theory challenges societal assumptions about time, energy, and resources, shedding light on pervasive able bodied perspectives. By highlighting the unique needs of individuals with disabilities, CRIP theory prompts a reevaluation of our understanding of tasks, accommodations, and expectations in both life and work. Originating from Alison Kafer's work in feminist, queer, CRIP, this theory delves into queer temporal theory, encouraging exploration of intricate connections between time, marginalization, and visibility. It challenges the conventional understanding of time and urges consideration of how individuals with disabilities navigate temporal aspects of their lives, acknowledging their diverse temporal experiences. For instance, this theory goes beyond the notion of just accommodation. It calls for an active valuation and integration of unique perspectives. For example, a school implementing CRIP theory might emphasize not only providing ramps for wheelchair access, but also fostering an inclusive curriculum that represents diverse perspectives, experiences, and contributions of individuals with disability. So this goes beyond meeting basic accessibility standards. It actively values and integrates the unique viewpoints of students with disabilities, creating a more enriching educational environment for everyone who is involved. In the last part of my presentation this morning, let me deal with private discrimination, which is perhaps a little more controversial. I will explore the complex terrain of equality and justice, where we find ourselves confronting a formidable obstacle, the domain of private discrimination. This dimension, often concealed within the folds of societal interactions and private arrangements, demands our attention as we unravel the layers of inequality embedded within our society. I would like to begin by dissecting the jurisprudential origins of anti-discrimination law in India. A crucial dichotomy surfaces: formal equality and substantive equality. Article 14 and Article 15 of our Constitution birth these perspectives. Legal equality, grounded in the equal application of the law, encounters its counterpart, substantive equality, which delves into nuanced characteristics of groups, acknowledging the potential for indirect discrimination. While legal equality ensures uniformity in application, substantive equality recognizes the need to accommodate differences within the application of the law. Articles 15.2 and 17 of the Constitution directly address discrimination by entities beyond the state. Article 15.2 prohibits disabilities, restrictions, or conditions for citizens concerning access to places like shops, hotels, wells, and places of public resort. Article 17 abolishes untouchability, providing a constitutional shield against certain forms of private discrimination. However, these provisions, though crucial in themselves, are confined to specific places and practices, illustrating the constitutional recognition of the need to combat private discrimination. The oversight in recognizing indirect discrimination as a form of injustice, coupled with the absence of proactive measures to address it, reflects fundamental assumptions about the nature of the right against discrimination. Transforming this paradigm necessitates a thorough examination of how laws impact the opportunities, freedoms, and dignity of diverse societal groups. Drafting rules around indirect discrimination demands a nuanced exploration by the judiciary into differentiating it from direct discrimination, delving into the intricacies of both intention and effect. This intricate interplay between intention of the law and its effect, as illustrated by the Supreme Court, compels a holistic reassessment of the foundations of the right against discrimination. I would like to ground this theoretical exploration briefly made by me in the harsh reality of housing discrimination, drawing attention to a glaring example from the Vattavada Panchayat in Kerala. Here, members of the Chakalinian community, identified as Dalits, experienced the egregious denial of entry into local barber shops. The discrimination faced by Dalits extended beyond barber shops and encompassed access to water, a poignant reflection of societal bias. Dr. Babasaheb Bhimrao Ambedkar's insight into the social and cultural implications of water was profound. He keenly recognized the intersection of water with caste dynamics, acknowledging its role in perpetuating complex hierarchies. Water was not merely a source of sustenance, but a deeply contested entity entangled with caste based exclusion. This manifested through denying Dalits access to water sources, monopolizing control over water bodies by upper castes, embedding caste biases in cultural and religious contexts related to water, silencing Dalit narratives and wisdom on water, and relegating discussions on caste and water as peripheral. For Dalits, water was not just life giving, it became a symbol of anguish and segregation. The Mahad Satyagraha became a focal point for social change based on the quest of access to water. To further grasp the pervasive nature of private discrimination, consider the plight of individuals facing bias in employment based on their sexuality. This is not a hypothetical scenario. It is a harsh reality faced by many individuals, shedding light on the urgency of dismantling discriminatory practices deeply ingrained in private spheres. Moreover, another example came to my attention when one of my young law clerks recently showed me an Instagram reel depicting the entrepreneurial journey of a determined young woman. Despite her innovative business ideas and evident merit, the reel revealed the systemic discrimination she faced in securing funding. Investors, influenced by gender bias, dismissively overlooked her proposals, exemplifying the pervasive challenges women encounter in entrepreneurship. Her resilience in the face of these discriminatory barriers served as a powerful testament to the urgent need for challenging and transforming biased norms within private spheres. These experiences collectively underscore the imperative of dismantling discriminatory practices and fostering inclusiveness within the private spheres of our society. The Supreme Court's decision in Zoroastrian Cooperative Housing Society Limited versus District Registrar Cooperative Societies in 2005 comes to mind when we talk about discriminatory practices in the housing sphere. In this case, a Parsi Zoroastrian Cooperative Housing Society, guided by bylaws that explicitly restricted non Parsis from becoming members, came under legal scrutiny. The society contended that it was a Parsi Zoroastrian association, exercising its rights under Article 19(1)(c), which guarantees the freedom to form associations, and argued that this right allowed them to exclude membership on the basis of religion. The court, accepting the argument, construed the issue as to whether cooperative societies, essentially being associations, could legitimately discriminate between citizens. The Supreme Court concluded that they could discriminate. This judicial stance raises profound and intricate questions about the delicate balance between individual freedom and the imperative of combating discriminatory practices within private entities. There is a sting in the tail to this judgment. This judgment overruled sub silentio, a decision rendered by me as a single judge of the Bombay High Court, where a cooperative housing society I held could not discrimination on the basis of caste or community. The sting in the tail was that my judgment as a single judge of the Bombay High Court was reported in Scale, which is exclusively devoted to printing Supreme Court judgments. Well, I got the report in Scale, but we lost the wider battle to the Supreme Court. And as they say, the Supreme Court is not right, is not final because it is right. It is right because it is final. I guess somebody would say that about some of my judgments later on, I guess. The judgment in the Indian Medical Association versus Union of India, likewise in 2011, has expanded the scope of constitutional protection against horizontal discrimination. By incorporating educational institutions within the meaning of shops under Article 15(2), our court has ensured fundamental rights protection for anyone facing discrimination in such establishments. This marks a constitutional response to horizontal discrimination, providing a potent tool for challenging exclusionary private covenants. This renewed interpretation calls for an exploration of other services considered public in the relevant sense, opening avenues for challenging discriminatory practices across diverse sectors. And the last 2 minutes, may I just wrap it all up by having a section which I have titled Crafting an Inclusion of Tomorrow. As seen through the examples which I have reiterated in the course of my presentation, courts have recognized that a seemingly neutral law might be a tool of oppression for a particular group. To truly achieve substantive equality, the impact of its provisions must be understood in the context of social realities. Overcoming socially ascribed roles necessitates transcending artificial public private dichotomies. Addressing power imbalances wherever they thrive becomes an imperative of our time. Our laws are powerful tools in opening up our public spaces as well as curbing private discrimination. Equally important, if not more, are the mechanisms that mediate access to law. A simple requirement that seems to be neutral, such as that the cause lists that all the courts across the country publish may exclude certain persons from accessing the law itself. Simple requirements like these highlight that discrimination is still embedded within the processes of our system. If a person with visual impairment is unable to access the cause list or is having to spend more effort and time than anyone else to peruse the contents of the cause list, the promise of equal law and equal protection of laws loses some heft to them. Recently, in 2023, the Supreme Court State of the Judiciary report indicates that only 30.4% of district court complexes have separate washrooms for persons with disabilities, and other infrastructural support such as tactile paving and wheelchairs are available in less than 30% of our court complexes. In preparing for their day in court, rather than sharpening their arguments and submissions, a lawyer or litigant is forced to account for parking arrangements and spot washroom facilities inside the court complex. Leave the spaces of our courtrooms to access a sanitary napkin dispenser. Is the burden not on us to cure this situation? They have access to the law and also the court, but the hurdles placed in their way will qualify the ability to actually benefit from the access which we have provided to them. This immediately places them at a disadvantage compared to those who could spend more time with their files. Inadvertently, then, we are telling our lawyers and litigants that it is not the law's concern to intercede between such hidden forms of discrimination. To truly overcome stereotypical roles, the law and policy should transcend the public private dichotomy and address power imbalances regardless of their location. This requires a comprehensive approach that considers societal context, historical perspectives, and the jurisprudence of discrimination law. By doing so, we pave the way for a society where equality is not mere a slogan, but a lived reality for all our members. The legal landscape must evolve, weaving a tapestry that accommodates differences, eradicates biases, and ensures substantive equality. Let us then, in our tribute to Justice ESV, as legal practitioners, scholars, and advocates, pledge to be architects of change, contributing to a tomorrow where the rights of every citizen, regardless of ability or background, are not just protected but celebrated, and excesses, regardless of the location, are interfered with. Thank you. Namaskar.
I request everyone in the audience to give a standing ovation to the Chief Justice. Thank you. Locating it in the context of discriminations in the public and private spheres and highlighting the overlaps and tensions between the two spheres. May I now invite Professor Nigam Nugehalli, Registrar of the National Law School of India University, to deliver the vote of thanks.
Not now, please. Let's continue, please. Yes, please. Thank you. Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Justice B.V. Nagratna and family, esteemed Supreme Court, High Court, and District Court judges, distinguished guests, ladies and gentlemen. It is my privilege and honor to propose a vote of thanks on this momentous occasion of the inaugural Justice E.S. Venkataramiah Centennial lecture. On behalf of NLSIU and the benefactors of the lecture, Honorable Justice B.V. Nagratna and family, I would like to express my sincere gratitude to the Honorable the Chief Justice of India for his enlightening and inspiring speech on the constitutional imperatives relevant to addressing discrimination in private and public spaces. His words have reminded us of the vision and values of our founding fathers, who gave us this magnificent document that guides our democracy and safeguards our rights and liberties. His speech has also highlighted the challenges and opportunities that lie ahead for the judiciary and the nation, and the need to uphold the constitutional principles of justice, equality, and fraternity. I would like to thank Honorable Justice of the Supreme Court, Justice B.V. Nagratna, for endowing this lecture and whose generous support has made this event possible. Your generosity and goodwill has enabled us to organize this event and to celebrate the Constitution and its achievements. Your sponsorship has also helped us to spread awareness and education about the Constitution and its importance among the public. I would also like to thank all the distinguished persons who have graced us with their presence today, and I'm going to read the names out. Honorable Governor of Andhra Pradesh, Justice Abdul Nasir, Honorable Judges of the Supreme Court of India, former Chief Justices and former Judges of the Supreme Court of India, Honorable Justice Prasanna B. Varale, Chief Justice, High Court of Karnataka, Honorable Justice T.S. Shivagyanam, Chief Justice, High Court of Calcutta, Honorable Justice Ramachandra Rao, Chief Justice, High Court of Himachal Pradesh, Honorable Judges of the High Court of Karnataka, Honorable Judges of various High Courts, learned Principal District Judges and Judicial Officers from Karnataka, President and Office Bearers of Advocates Association, Bangalore, learned senior advocates and advocates from Delhi, Bangalore, other cities, and on online platforms, members of the governing bodies of NLSIU, Mr. Bharat Kumar, Registrar General and other registrars, High Court of Karnataka, the Secretariat of Honorable the Chief Justice of India, and Sri Rakesh Kumar, Registrar and other registrars, Supreme Court of India, the Secretariat of Honorable Justice B.V. Nagratna, Vice Chancellor and faculty past and present of NLSIU, learned deans and faculty from various law colleges assembled here, Vice Chancellor, Administration, and staff of the Bangalore City University for providing this auditorium. Protocol officers and officials of High Court of Karnataka and Mr. Kanakraju, retired Joint Registrar Protocol of the High Court of Karnataka. Officers and officials of the police, electricity, horticulture, water, fire service departments for extending essential logistical support for this program. Thank you very much. Distinguished invitees and guests, relatives, friends, and associates of Justice C.S. Venkataramiah, members of the press and electronic media assembled here, and the volunteers who have assisted us in organizing this function. Your presence has added value and prestige to this event and has shown your commitment and respect for the Constitution and the judiciary. I would also like to thank the students who have turned up here in big numbers. The Chief Justice is very popular among the students, and today's turnout is yet another reminder. Today's turnout is yet another reminder that the young people in this city and beyond are eager to hear more about the integration of our nation's constitutional principles in public and private life. Without the active participation and interventions of various people, this event would not have been possible. I thank Ms. Nayantara for her unstinting support and assistance at all stages of this event, from conception through invitation and ending with the organization at this venue. We are grateful that she was able to give so much of her time for this event. She was ably supported by Ms. Anandita Reddy, Ms. Priyanka BV, and Ms. Vidya Pai, and Ms. Praval B. Mr. Praval B. At NLSIU, we had a team led by Ms. Akanksha and Mr. Manish, and they made sure that every aspect of this lecture was planned and executed meticulously. I want to thank also Mr. Shailesh, who led the logistical operations for this event, and he was assisted by Mr. Samirullah and Ms. Vidya and Ms. Savitri, who managed the logistics and the protocol for this event. I want to thank Ms. Vinayshri for press and publicity, Ms. Seema for coordinating the invitations, and Dr. Sudhish for being our Master of Ceremonies today morning. We also had a number of student volunteers from our university for this event. I want to thank them especially. Their energy and enthusiasm has made this event that much more memorable. I would like to end on a personal note, as the Vice Chancellor mentioned, Justice. I also want to thank Mr. Gopal Krishna and Ms. Prerna for their support and help here. I would like to end on a personal note. As the Vice Chancellor mentioned, Justice C.S. Venkataramiah taught both the Vice Chancellor and me when we were first-year law students at NLSIU. As an 18-year-old, listening to the former Chief Justice on contemporary constitutional issues was an unforgettable experience. I want to thank him today for giving his valuable time to the university and sharing his vast scholarship with us. It is our aspiration and hope that the university will continue to carry on the traditions of scholarship that he set for us. Thank you very much.
Thank you, Professor Nogueirli. I now request everyone to stand up kindly for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you, everyone. The dignitaries on the dais will now be leaving the auditorium.